Well, good morning, everybody, and thanks for being here. Jacob, you look like you have one heck of a setup there, man. We need to come to your house. You've got like a whole setup for doing podcasts. All right, let me do the Zoom so I can share my screen with everybody here so you guys can see what we're going to look at. Yeah, it looks good. All right, so you guys should be able to see the what to know about real estate. I'll try and change it up a little bit. Some of you may have been through this class before. Jacob's the only one that we can see. Everybody else is hiding, but welcome everybody. And then Raquel, she decided to grace me in person, thankfully, uh, because it's freezing outside. I'm not surprised to not see very many people here. So, but thanks for tuning in today. The class is informal. Ask questions as you have them. Um, things I would say, just try and keep your comments like about specific stories or specific questions to yourself until after we're done with the class, just because it can get a little bit monotonous when everybody's asking hypothetical questions or telling stories about what they ran into and something like that. But if it's something that you feel necessary to share or ask a question at that time, please feel free to do so. So I created this slideshow a few years ago. It usually takes a couple hours to get through. We'll try and get through it pretty quick. And again, it just depends on how many questions you guys might have. So it's just a general overview and topics that you'll encounter while you're in real estate. So as we get started, one of the things I'll say is, if you haven't created an LLC or a S corporation or anything like that, talk to your tax preparer, because it is a great idea. You get tax incentives when you're not just a sole proprietor and run everything under your social security number. As long as you own an LLC or you have ownership in an LLC, we can pay that LLC. And then there's tax benefits to that. So, for example, on the first, I believe it's up to $250,000, there's no income tax in the state of Ohio for a small business. And so therefore, like, I know each year that I file my income taxes, I usually end up getting back, and I've never even paid into the state of Ohio. So it's kind of weird. I don't know how you can get money back when you haven't paid into it, but that's how their taxes work. So I would say, I've created a limited liability corporation or an LLC for myself, but you can still write off your miles, anything, your fuel, and anything like that, whether you're a sole proprietor or you have an LLC. But the LLC gives you better protection as well in case for some reason that you're sued or whatever the case would be. Hopefully that never happens, but it keeps you and your business separate. So people can't come after your home and things like that. So we can be sued for any reason at any time in this wonderful business, well, in this wonderful world, period. So advertising, this is one that gets agents a lot. So there are a lot of agents that advertise incorrectly, not just at our brokerage, but at many brokerages. And you think, well, they're doing it. Why can't I do it? So one of the things you may not be aware of is that Ohio license law does have an equal or greater prominence rule for an agent's name or a team name versus the brokerage name. So the brokerage name, Keller Williams Legacy Group Realty, it must always be equal to or greater prominence than the agent's name in all forms of advertising, whether it's on a business card, a pen, a license plate cover, your car that you have wrapped, whatever it is, it must be equal or greater prominence. That's not a Keller Williams thing. That's not a Rich Cosgrove thing. That is a state of Ohio. That has nothing to do with us. So that's all brokerages. Again, you are going to see agents violate this rule all the time. I can think of so many agents right now off the top of my head that have banners out there or just have signs that their name is like three or four times the size or more prominence. Maybe it's a different color, different font than the brokerage name that they're at. And then there are some agents that just don't put the brokerage that they're at all on there, which is another violation. So make sure if you guys have questions, you can send them to Amanda or myself. We're both happy to look at anything before you create it. One of the things I'll say about the companies around here, not all of them understand Ohio law. So just because they approve or create a sign or a business card or a website for you does not mean it's compliant with Ohio law at all. So we work with ALD signs. They know what the rules are and they follow them when they create the sign. So we know that your business cards or your signs are going to be compliant if you're going through ALD. But if you go through somebody else, they do not know Ohio rules or laws. They will design whatever you tell them to, whatever you approve. All right. Let's talk a little bit about teams. So, any team that is formed after July of 2021, you must include the word team or group. If you do not include the word team or group, that is a violation if your team was created or group was created after July of 2021. Anybody previous to that is grandfathered in. It's also, you want to make sure that you cannot use the words realty or associates in a team name. Again, there are grandfathered teams like Jose Medina and Associates. That's grandfathered in because that was created many years before 2021. Okay. But you creating a team name now, you could not put the word realty in it and you can't put associates in it. And then the full brokerage name must be in all advertising. So I guess I'll ask you guys, what is our brokerage name out of those three red on the bottom left? Nobody want to give a guess? Nope, we got a couple in the chat, maybe. All right. The last one, three. Yep, last one. Okay, good. So that is correct. You guys are correct. Keller Williams Legacy Group Realty is actually the brokerage name. And the brokerage name, as far as the state of Ohio, is Legacy Group Realty. So that is the name that must be equal to or greater prominence than your advertising, your name, or a team name. Okay. So when I say all forms of advertising, that's exactly what I mean. It doesn't matter if it's clothes, if it's shoes, if you're putting something on social media, you have a billboard, a website, water bottles, pens, doesn't matter what it is, the equal prominence rule falls in that. And I will tell you, like I said, now that you know that, you're going to see all the time that agents violate that rule. Now, the thing about real estate is we're a self-policing agency, so unless an agent turns in another agent, the Division of Real Estate is probably never going to find you and give you a fine. However, if they wanted to make an example out of anybody, they could, and it is legally permitted that they are allowed to issue a fine up to $500 per occurrence for every violation that they find. So if you have 10 real estate signs out there and you violated the prominence rule or you don't have the brokerage name, they could fine you $500 for all 10 of those signs, each of them rather. So you could have quite an experience with the Division of Real Estate. So based on what I just said, which one of these four would you guys say is correct? And you can unmute yourself so you guys don't have to use the chat, but you can, whichever one. So Paulette says left side. Brianna says top left.
Top left.
Okay. Rena's saying top left. All right. So you guys are close, but unfortunately, there is a word missing from the end of this on the top left.
Yeah, the
Keller Williams
realty.
Legacy Group Realty is the name of our
Yeah.
brokerage. And so therefore it's actually this one on the bottom left. That is actually the name of the brokerage. And my name is smaller than Keller Williams Legacy Group Realty. So if I were advertising, this is the one that I want. Now you will hear the division will say sometimes that, you don't have to use the word realty in your name, but all of our logos have Keller Williams or KW Legacy Group Realty in them. And that just keeps you compliant. We don't want to have just Legacy Group because if you start putting that, it's going to mess up the logo that we have. But then not that I care about the logo so much, but it's going to mess up the fact that you're going to have advertising that's going to look totally different for the same brokerage. So somebody might have Keller Williams Legacy, somebody might have Keller Williams Legacy Group, and somebody might have Keller Williams Legacy Group Realty. We want to make sure that we're compliant and stick with Legacy Group Realty so that all of the advertising looks the same throughout the brokerage. Okay. All right. And then advertising a listing. So talk a little bit about, the first thing that you have to ask yourself is the listing mine? If the listing is mine as the listing agent, I can absolutely advertise the listing. The second question you might ask is, does the listing belong to Keller Williams Legacy Group? So if you yourself don't have any listings as a new agent, but you want to drum up business and you want to do a social media post, you could say, well, does the listing belong to Keller Williams Legacy Group? Okay, yes, it does. Well, if it does, then you should call that listing agent and ask them if you can have their permission to advertise that listing. Because there are some agents that'll say, absolutely, advertise my listing away. And there will be other agents that will say, no, I'm advertising my listing and I want to drive all traffic and buyers to me because I know the house the best, or I want to pick up the buyer. So they may not give you permission. As the broker, all listings belong to the brokerage. And so I do not have a problem with you advertising any Keller Williams Legacy Group listing as long as you have the agent's permission. So if it's not a Keller Williams Legacy Group Realty listing, then you need the written permission from the broker, not the listing agent. So if let's say, for example, Howard Hanna has a great new listing and I want to advertise it, if I reach out to that broker and ask them in writing and they say yes, and it's in writing that you have our permission to advertise this listing, then you can. You still have to pay tribute to that company. So I could list Howard Hanna's listing, but I would have to say, check out this great new listing, courtesy of Howard Hanna Real Estate Services, blank agent. If you'd like to take a look at it, please give me a call. Something like that. So you can pick up buyers that way if you want to and advertise that way. But again, you need the broker's written permission before you advertise any listing. And I will just repeat again, I don't care what listing at Legacy Group, if it's our listing, but there are agents at our brokerage that do not want you advertising their listing. And so therefore, please always make sure to reach out to the listing agent if it's a Keller Williams Legacy Group listing. Last thing I'll say about this is not all Keller Williams are the same. As you learned, our brokerage name is actually Legacy Group Realty. It's not Keller Williams. Keller Williams is a franchise name, and the Division of Real Estate doesn't recognize that name. So just because it's another Keller Williams franchise listing does not mean that we get to advertise it. Keller Williams Legacy Group is its own brokerage. Keller Williams Shervinick is its own brokerage. Keller Williams Living and Keller Williams Elevate, those are all their own brokerages. They have their own broker, they have their own staff, and they are considered completely separate by the Division of Real Estate. So you can't work from those offices. You can't advertise an address from those offices. Those offices belong to that brokerage, just like the Keller Williams Legacy Group offices belong to ours. So what addresses can you use? If you're still sending mailings or anything, the return addresses, these are the return addresses that you're allowed to use. We currently have the 5 office locations that are open offices for everybody. So we have our New Philly office, Worcester, Mansfield, Alliance, and the Canton office. But then we also have mega agent offices, which we have in Mansfield, Stephanie Webb's team, in North Canton, Jose Medina on Cleveland Avenue. And in Canfield, we have the Erica Winter Sauceman team. So even though all of those 8 addresses you're legally allowed to use, typically you wouldn't use one of the MAO offices because that's a mega agent office. They pay for their own office. That's their sign, their advertising. They pay for all their utilities, all that stuff. It's their own office. They just have to advertise Keller Williams Legacy Group because it's the brokerage name. And so those offices are all approved. But the top 5, you can use any of those offices. And I know Paulette's on here, soon to be Southern Ohio, close to the West Virginia border. She's got an office there, and so we'll get that one registered, and we'll add that to our slideshow as a mega agent office. All right, social media rules. We'll talk a little bit about what you can and can't do on social media. And the social media has what we call a one-click rule, and that's what you see down here. I have in small print, one-click rule. So in the event that you advertise a listing on social media and I click on it, as long as when I click on it, it takes me back to something that has the brokerage name on it, Keller Williams Legacy Group Realty, then you're in compliance. But what I see often happen many times is an agent will list a listing, a new listing or advertising something on their personal Facebook page. And when you click on it, it does nothing because it's your personal page and there's no link or anything to take me back to either an MLS printout or a YouTube video where you have the information or the brokerage website even perhaps. So you just want to make sure that when you're advertising on social media that the best practice is create a business page for Facebook, create a business page for your YouTube if that's what you have, or anything else that you have. You want to make sure you have a business page rather. Post on your business page and then share it to your personal page. That is the best way to do it. The same thing is true for the MLS. There's a link in the MLS. You can share that link for a listing that you might have, and that will go to your business Facebook page or your personal Facebook page. Again, that one's a little bit easier to use because it gives you a link that takes you back to the MLS. And so I can post that one anywhere and I know that I'm compliant. So again, you just want to make sure that to be compliant on social media, that if I click on a link or click on something that's going to give me more information, it better have the brokerage name somewhere. Now, if on your personal page, like I think my personal page, I think I have the Keller Williams Legacy Group Realty logo on it. I can post pretty much anything I want on there because I'm compliant since I have that on my page. But most people don't blur the lines of their personal page and business page because they want to engage with clients on their business page, and their personal page is more for personal stuff. So you just want to make sure that you're keeping those compliant and following the rules as far as your prominence rule, as well as the one-click rule. Okay. All right. MLS. So we have many multiple listing services. I'm going to talk to you a little bit about our biggest one, which is MLS Now. So we are actually members of Firelands MLS, Columbus MLS, Ashland MLS, Mansfield MLS, MLS Now, and I feel like I'm forgetting one, but I don't think so. So we have lots of MLSs that we are a part of. Most oftentimes are members out of the Canton office location, down where Paulette is, in Southern Ohio, and then also towards till you get to about Mansfield. Almost everybody is in MLS Now. Okay, that's the normal MLS that we all have. When you get to Firelands, Firelands is going towards like the Toledo area. That's 5 counties up there. If you're listing something towards that area, first of all, I hope you know that area very well if you're listing something up there. But that is 5 different counties, and you would have to join that Firelands MLS. If you're listing something in Columbus, that's the Columbus area Metro MLS. You'd have to be a member of that MLS. If you are listing something in Ashland, you've got to be a member of the Ashland MLS, soon to be going away, soon to be joining Mansfield, but nonetheless, you would have to put it in there. And MLS Now requires when we're in their territory, you also put the listing in there. So some agents put their listings in 4 or 5 different MLSs because they might be in the Mansfield area where it overlaps, or Ashland, or down towards Columbus. So you can put it in multiple MLSs, but I'm going to talk to you a little bit about MLS Now. So listing entry in any of the MLSs is the agent's responsibility. You put your own listings in. We don't check for fair housing compliance or anything. The MLS does. But please make sure that when you're creating your descriptions, a lot of agents are using AI now, and that's fine. You can use AI, but you're not going, the Division of Real Estate or the Federal Fair Housing Commission is not going to look the other way if you have fair housing violations in your description and you say, oh, well, AI did it. Well, that doesn't matter. You have oversight over what you're putting in multiple listing service. So when you're entering a listing, you need to make sure that you're entering the listing within 48 hours of taking the listing, or whatever it's dated for on your listing agreement. So if my listing agreement is dated for January 18th, the 18th would have been Saturday. No, the 18th would have been Sunday because today's Tuesday. And so therefore, I would then have 2 business days to get that in the MLS. So let's say, for example, I got it signed on Sunday, and then all of a sudden my client calls and says, you know what, I don't want it in the MLS yet. Don't do that. I need another week before I can list my house with you. And so you don't list it. Well, then unfortunately, you're going to have to go back and get the seller to re-sign the listing agreement or initial next to the date change, because you will not be able to enter that listing into the MLS for next week when it was dated for the 18th. You only have 48 hours to put it in the MLS, and you only have 24 hours to put it in the MLS if you do any public marketing. So if I go out, like let's say yesterday or on Sunday, I took a listing, I was out at the house, got my seller to sign the documents, and I put the sign in the yard. That is a form of public advertising, which means I would have to have that listing in the MLS within 24 hours. That does not exclude federal holidays and weekends if I do any public marketing. And that goes back to NAR's Clear Cooperation Agreement. If I don't put the sign in the yard, but I took the listing on Sunday, I have 48 hours excluding federal holidays and weekends to get that listing in the MLS. So you have to know if you're doing if a Facebook post is public marketing, a video from the house is public marketing. That's all public marketing. Even if you don't give the address, you are publicly marketing a property if you're advertising it on Facebook or somewhere online. Okay, so you want to make sure that you are compliant with MLS rules. And then status changes, you are responsible for the status changes. So you have to make status changes within 48 hours. And what I mean by that is if I take a listing today and it goes under contract tomorrow, then I have 48 business hours to change the status to either under contract allow showings or under contract no showings. And that is up to the seller on whether or not they want to have showings on the property. So if you put a property under contract, no showings, that means you're not even allowed to show it. You can't show it for backup clients. Another agent can't show it for backup clients. If it's under contract, no showings, that means no showings. You can do an appraisal, you can do inspections, but there are no showings on the property. If your seller wants to continue to have showings on the property for backup offers or just in case something happens, they might feel like maybe the buyer's not really secure or they are comfortable, even though the buyer's secure, of having a backup offer come in, then you would put it under contract allow showings. So have that conversation with your seller once you get a property under contract. So, sometimes the seller will say, I don't want any more people in my house. I've had so many showings and I haven't been able to be home. I don't want any showings. And so therefore you'll put it under contract, no showings. MLS classes are available. You can take any of the online classes, but also if there's, if a few of our agents want to have a class here, we can definitely have somebody from the MLS come in and they'll teach you how to use the MLS, run reports, do all kinds of fun stuff. But those are always available. And then we don't use TOMK very often, which is temporarily off the market, but I just want to make you aware of it. If I had a client that called me and said, hey, Rich, I had somebody passed away in my family and I'd like to take my house off the market for the next week. I don't want any showings. I've got family coming in. I could use the temporarily off market status change where I would change it to temporarily off market in the MLS. And in the broker remarks, I have to put a back on market date. That's what the BOM is there at the bottom. BOM date is back on market date. And then I would put the date in when we think that the seller is going to put the house back active again. You can move that date up. You can push that date out. But I will tell you, try and have a back on market date that is accurate because agents and buyers pay attention to that kind of stuff. And if they wanted to see the house and now it came off the market, and all of a sudden you put a back on market date of February 14th, but then you somehow move it up to January 31st, and it goes under contract and the other agent didn't realize it and their buyer didn't realize it, they're going to be very upset that they didn't get in the house. And your job is to make sure that you get as many people in the house and get the best terms for your property as you're representing the seller as possible. So you really don't want to mislead the public on when a property is coming back on the market. Okay. All right, MLS continued. So again, this is just for MLS now, but every 6 months you have a bill. It's $228 and you have 30 days to pay it. We will be billed here coming up in February and you'll be billed again in August. If you do not pay that bill within 30 days, the MLS will send us a nasty gram, is what I call them, because they can threaten to shut off our entire brokerage, even for one agent not paying their dues. And they will follow through on that threat. They will usually shut the agent off first, but then if it remains unpaid and we as the brokerage don't take action to either send your license back, or get you to pay it, they will shut off the whole office. That's how they get us. So it's very important that if you can't pay your dues, you let us know immediately so that we can figure out a plan and get those paid or have to send your license back. All right, and then the fees are billed monthly to Keller Williams for agents that are in Mansfield and Ashland. That will soon be changing. Mansfield is going to start billing their agents through the MLS through Navica, so that'll be wonderful. We won't have to do that anymore. And Columbus Flex MLS is what it's called. They bill annually, not cheap as the brokerage we just paid. I think it was $1,071 if I'm not mistaken. That was for the MLS and their local dues for the year. That did not include national or state dues. So they're pretty expensive. So if you want to be in that MLS and sell in that area, you certainly can, but it is not the cheapest one to be in for sure. MLS Now does include your Supra access. If you don't have a Supra app on your phone, please contact the MLS to download it and get a code. Not a lot of agents use the Supra lockbox. That's the blue electronic lockbox. I still use them because it is the best way to protect your seller from having their home either broken into because somebody, leaves a lockbox on there, and those lock boxes are very easy to get into if it's not a Supra. You can use a screwdriver or a hammer and pop them pretty much open. But oftentimes too, what we're trying to protect our seller from is that code doesn't get changed. If you have a code of, let's just say, 4 zeros on your lockbox, and that's what you choose to use, once a client sees that, now they have access to every lockbox you ever put on a property. And so unless you're good about changing those every time you put it on a property, it's really not the best idea to use a combination lockbox. A lot of people don't like Supra. I use them just as the broker to limit liability. I highly encourage you to do that, but I will also say, even if you choose not to use the Supra box on your own listings, you will encounter agents that will have a Supra box, and you will need to make sure that you're able to access that. So download that Supra app before you need it, because if you do it on the weekend, chances are you're probably not going to get it into a property. Okay. And then photo count, you need to make sure that in MLS now you have at least one photo, one primary photo of the exterior of the property must be in the MLS. The only exclusion to that is vacant land. If you have vacant land, you don't have to have at least one photo, but otherwise you do. And then the lawsuit, I kind of added this, maybe not the best section to add it in for MLS, but you cannot advertise your services as free. I think that we all understand that now. It's gone away, but we had a lot of times where agents, buyers agents would say, "Oh, well, you can work with me. It doesn't cost you anything to work with me. My services are free." Well, no, you were still getting paid. You were just getting paid by the listing company. And so unfortunately, that's what also prompted the lawsuit that we had against NAR back in 2024, where it got settled. So you never want to advertise your services as free. I have agents ask me, can I advertise a free CMA? Sure, you can, but I don't know of any agent that charges for a CMA. So I don't think a CMA is really a great service that you're advertising for free anyway. That's my personal opinion. And also, sellers are pretty savvy. They don't really need a realtor so much anymore to do a CMA. I mean, they can do many CMAs on their own just by simply using a web app that shows what's sold in their area. They can get a pretty good idea of what their house is worth. So, again, if you're going to advertise something, just make sure it's not for free. And then I want to share with you our Keller Williams Legacy Group info information. If you want, you can take a screenshot of this or save it. The information is in Dotloop under office information, but it's important that you have this because our EIN number is on there, our license number. If you are doing any HUD transactions are Fannie Mae, Freddie Mac. It's where a house goes into foreclosure and HUD gets it back, and they put it for sale on HUDHomestore.com. You'll start to see more foreclosures. We haven't seen those in many years, but you will start to see more of them as we progress out of still COVID and just different things where people have been able to put their mortgage on hold, if you will, for a while. And then our number in MLS now is C7579. That is our actual office number. Worcester has one, Mansfield and New Philly. You all have your own also. We're waiting on the one for Canfield, and then most likely, again, we will have one down in Southern Ohio as well for MLS now. So then Dotloop, you can find all this information in Dotloop. What you can't find in Dotloop is your NERDS ID or your M1 number. The NERDS number is a National Realtor database system that is specific to each agent. If you're a member of STAR, I think they start with 677 or 676, but you can go on the NAR website. You can find your own, whatever your number is. You need that for all your continuing education. So that's important that you make sure that you know what your NERDS number or M1 number is. I've had mine for 24 years. I couldn't tell you what it is. I know it starts with 677 and I just have it saved on my phone. That's what I recommend that you do because you'll need it in the weirdest instances. And then you'll be, oh, where do I find that at? You can always find it at the NAR site if you lose it. All right, let's talk a little bit about commission. You're all probably familiar with the antitrust law, the Sherman Antitrust Act. We cannot have conversations around commission with other brokerages. So I can't go to Howard Hanna or Cutler managers or agents and say, hey, I think that we should all have a standardized 8% commission. Let's all do it. Excuse me, that would be illegal. We can't have conversations. Well, what does your company charge? What does your company charge? Oh, well, I think it should be this, or I think it should be that, or this is what we charge. Those would all be antitrust violations. So we can't have those conversations. You in your career, you are going to get a seller client that's going to ask you, or a buyer client that's going to say, what's the average commission in this area? Or what's the average commission? And you cannot answer the question, well, it's blank. You can't say that. What you have to say is, I cannot tell you what the average commission is because it's 100% negotiable. What I can say is our commission at Keller Williams Legacy Group, the average commission is 6% or 3%, whatever it is that you uh, believe our average commission is. And or you can say, I can't answer what the average commission is, but I can tell you what I charge at Keller Williams. And that's what you can say. But you should never generalize that most agents in this area are going to charge 3% and I'm going to do you a solid and do it for 2% or something like that. You cannot say that. Um, Command commission request, the only way you're going to get paid if you have a deal is if you actually create a command commission request. If we get a check-in and you have not created that command commission request, you're not going to get paid, because when you create that request, that's when we do your compliance checklist. That's when we verify that you have your purchase agreement, listing agreement, all signed, agency disclosure, all of that stuff. That's what prompts that, is when you submit that request. I recommend submitting the commission request about 2 weeks before you have a closing. You can do it before, you're welcome to do it anytime, but if your commission changes or the price changes or anything changes, you're going to have to request the Cassandra decline that one, and you have to then process a new one, I believe. So I always like to wait until, like I said, two weeks, maybe a week before my closing. But that's when we check your compliance. If you don't have your compliance checklist, which can be found in Dotloop, it's under sales forms and listing forms. There's a compliance checklist. If you don't have everything that's needed and signed, we are not able to pay you until you get it. Now, there are some instances where clients might refuse to sign something, and if that's the case, you could put right on there, refuse to sign, and then you'll still turn it in. We will be able to get you paid. The standard additional commission that we charge at Keller Williams Legacy Group is $295. Teams and groups can charge more than that. If they want to charge $495 or $595 or whatever it is they want to charge, they're welcome to do that. $295 is an additional commission you must charge. And if you don't, it will come out of your commission. The only time that we don't say that you have to charge the $295 is if you have a client that has bought or sold 2 properties with you in a calendar year, you can then waive that additional commission on 3, 4, 5, 6, 7, 8, however many sales you have for that calendar year, but they should pay 2 per calendar year if they're working with you. And then if you're charging more than the $295, you want to make sure you're using the correct listing agreement and purchase agreement. Well, the purchase agreement is the same, but the listing agreement that has the additional commission pre-typed at $295, or you're going to use a blank one. That way you can write in $495 or whatever it is that you're going to write in. Blanks on the contracts are for commissions. In our listing agreement contract, it is for commission. It'll say, the brokerage is going to charge blank and blank percent. Well, the first blank is a dollar sign. That's where your $295 or $395 or whatever goes. And then the second blank is your commission, and that was the percentage. Okay. All right, showing time. You each have, I think, a monthly bill of around $72.50 per month. That includes the full version of showing time. That's $7.50 that goes towards showing time, which is very inexpensive to have that entire version. I say you should take advantage of it. There's a lot of things that you can do in showing time. So your listings, when you enter them in the MLS, they will automatically be populated in showing time after about an hour or so. You don't have to enter anything manually, but you can go in and set that up manually if you'd like to. But I typically wait. I go ahead and set it up in MLS, wait till it ports over, and then I go into showing time and go ahead and enter in any additional information that I want. The great thing is you can set up your client's feedback via email. It automatically, you're busy. You're out showing houses. You're out doing things. And so you don't want to be stuck to the phone waiting for an agent to call and say, hey, can I go show 1234 Main Street? And you go, oh, let me go to hold of my seller. Showing time will do all of that for you via text, email, or phone call, however the client wants to be reached out to from them. And then automatically when you receive feedback, the feedback can go directly to your seller, or you can review it first, however you set that up in showing time. But you can block out dates and times that your seller says, I don't want any showings on Mondays, or I don't want any showings on Thursdays between noon and 5, or whatever the case would be. You can block those out so you automatically don't have to worry about somebody trying to set up a showing during that time frame. The other thing that they have that's really nice, especially this time of year as listings are sitting on the market a little bit more, they have showing reports. So if you have a listing, let's say in Perry Township, that's listed at $230,000 and you're not getting any showings on it, You can go in and do a report in showing time, and you can pull up all of Perry Township listings that are between 2:15 and say 2:45, and it will give you a breakdown of how many showings they've had. So that way your seller can say, oh, no properties in this price range in Perry Township are getting shown, or no 3 bedrooms, 1 bathrooms are being shown in Perry Township, or oh my gosh, all of these are being shown. Is my house overpriced? So it's a great way to get price reductions, but also give feedback to your sellers. And then I've already talked about the text, email, phone calls, contacting the client. The other nice thing is you can set it up as a go and show. If you have a vacant property, you just click on the go and show, and you don't even have to worry about verifying with the seller to go in. It will just email them and let them know that an agent from wherever set up a showing for this day and this time. It's very nice. Appointment required. Of course, if you have sellers that live in the house, you want to make sure that they are aware that somebody's coming and they approve that showing. And of course, then Showing Time keeps a record of it. Again, I talked about the full version you get for $7.50 a month as part of your agent bill, which is super nice. I get the question a lot about who signs a listing or a purchase agreement. One of the things that I always remember from being licensed is it takes 1 to buy and 2 to sell. And what that means is if you have a married couple, one person can buy a house without the other one. But if you have a married couple, in Ohio, we have dower rights. A married couple, one spouse can't sell the house without the other one, even if they're the only one on the deed. You have to have both signatures. So when you're getting a listing agreement signed, you want to make sure to ask the person whether they have a wedding ring on or not. You should ask the question, are you married? If so, I need to get your spouse's signature. Now, you might sometimes get somebody who'll say, yes, I'm married, but I owned this house before I was married. I'm the only one on the deed. That's great. However, in Ohio, there are dower rights, and unfortunately, your spouse has ownership rights in the property as soon as you became legally married. And that spouse will need to sign off at closing. And so I always recommend that you get the listing agreement signed by both parties as well, because what can happen is a seller could say, oh yeah, I'm the only one on the deed. I know legally I'm the only one that has to sign this. My spouse will sign off at closing. And you're like, oh, that makes me feel comfortable because that's legally the only spot that they have to sign off of is at closing. And then what happens is you end up getting somebody that's going through a divorce. The spouse gets to closing and sees that there's $80,000 in the net amount, and they say, well, I'm not signing anything until I get half this money, or whatever the case would be, or I'm not comfortable with you selling the house. I didn't agree to this price, whatever the case is. So you always want to make sure on a listing agreement, you're getting both signatures if the party is married. If you're dealing with an estate and you have siblings that own the property and they're both married, you're getting 4 signatures on there. If you have 3 siblings, you're getting 6 signatures if they're married. So you just have to make sure that you understand who owns the property and if the people are married. Now, in some trusts, you might have a trustee, and in that case, you don't have to worry about getting both signatures from the married couple because one of them is a trustee and one of them is not. So you need a copy of the trust document that explains who is able to sign on behalf of the trust. Same thing with estate. You should be given a court documentation that says that a person is either the executor or administrator that can sell the property on behalf of the estate. You need that piece of paper, and the title company is going to need that piece of paper. And then power of attorney, get a copy of the power of attorney documents, because just because I say I'm power of attorney for my father doesn't mean I legally am. You wouldn't know that. So get a copy of those documents. And remember, power of attorney dies with the human. If the person that I'm power of attorney for passes away, that's it. My power of attorney is dead too. I can no longer sell their real estate because they passed away. Power of attorney dies with the human. All right. Purchase agreement. Again, we talked about this. Check with the lender if you need one person or 2 people's names on there if they're married. Sometimes, because again, 1 can buy and 2 to sell, sometimes a lender will say they're not on the loan. I don't want them on they can be on the deed, but they're not on the loan. So don't put them on the purchase agreement. So check with the lender on that. Same thing with trust. Get a copy of the trust. Estate, again, mention that. Power of attorney, get a copy of the power of attorney. And then divorce situations when buying. This is tricky. So sometimes you'll get a spouse that'll say, I'm leaving my spouse and I don't want them to know that I'm buying a house. I'm taking $50,000 out of our savings account and I'm putting it down on a house and I'm buying this and I don't want them to know. But they'll have nothing to do with the house. Well, if you buy a house, even if you're in the middle of a divorce, it becomes a marital asset. So you've got to be very careful when you are representing your buyer to understand that you have the knowledge to explain to them, you need to check with your attorney because under my understanding of it is dower rights apply. And unless your spouse is going to sign off of dower at the closing table, you're not going to keep this from them because they're going to have to close on the property with you. So that's very important, especially, I've seen in my career where it's, a very delicate situation where a spouse is being abused or whatever, and they're trying to get away. You want to help them, and yet you don't want to get them in more legal trouble. So just make sure that you understand if it's a divorce situation, they better make sure that they're talking to their attorney and figuring out how they're going to do this without the other spouse knowing. All right, escrow letter. An escrow letter is once you get a property under contract, the title company is going to ask you for an escrow letter to understand what the contact information is for your buyers and sellers, what the commission amount is there a home warranty? If so, who's paying for it? How much is it? Who's paying any closing cost in addition to their regular closing cost? Am I giving a credit of closing cost help to a buyer? Are there any open inspection invoices? Was there mold in the attic and the mold inspectors getting paid out of closing? What is the co-broke information's contact information? And what is the closing date and loan officer information? So it just gives a great complete package of all the information that the title company will need to know in order to close out this transaction. You are responsible for completing your own escrow letter. We have a template in dotloop for you, but again, this is one of those documents I usually do about a week, max 2 weeks before closing, because if the commission amount changes or inspection invoices come in, or if a home warranty gets negotiated in or anything like that, I want to make sure I have the most up-to-date information. Choosing a title company, you're going to hear all kinds of different stories. You're going to hear people that have been in the business for 60, 50 years or less or whatever or more. And they're going to say, oh, well, in this area, the buyer gets to pick the title company, or in this area, the seller gets to pick the title company, or it's seller's choice or whatever. So the answer is none of those are true. It is 100% negotiable, and it is up to the buyer and the seller what title company they use. You can make recommendations, but if people are fighting over a title company, agents, you can kill the deal. And it is not worth killing the deal for your client because no ABA is worth that much money to you. And you want to make sure that your client is serviced. That's the point of having good relationships with title companies, whether they're an ABA or not, is the servicing of the client and the consumer. That's what we care about more. So the old school rules, like I said, would be buyer's choice or seller's choice. Sometimes an agent is stronger than another agent, and they'll make up a story sometimes and say, oh, well, my clients used this title company before, and that's who they want to use. Miraculously, that's the one you have an ABA with. But whatever. Again, it's not worth arguing over. You want to try and do business with agencies that you know, like, and trust. As long as it is an agency, a title company that you know, like, and trust, it really doesn't mean that you have to strike it out and put your ABA in there. If you do have an ABA, though, that's so like we have ours with American Title. If you do, there's going to be an ABA disclosure that you must get signed in order for them to start the title work. And it has to be signed by our client. So like Keller Williams Legacy Group has an affiliated business arrangement with the title company here, American Title. So if you are not a partner as an agent with American Title, then there is an ABA for non-members in dotloop. You'll need to get that signed before they can start the title work. If you are a member of American Title and you have an ABA with them, they will send you a copy of your own ABA having your license your name on it. And it discloses then that you are affiliated with that title company. So it's very important that you understand those ABAs. All right, home warranty. We typically use America's Preferred Home Warranty. We do have an agreement with them, as does Keller Williams. If you sell a home warranty, that does not mean that you get $100 from America's Preferred Home Warranty. The reason that they would pay you to get $100 is if you fill out the data collection sheet. And if you don't want to use paper, you can go on their website and you can fill out all the information of when the buyer's taking possession of the house, what the closing date is, the year the house was built, how many square feet it has. And I don't know if this is true or not. Some agents have told me you no longer have to put in the make or model of the appliances, like the furnace, hot water tank, or anything. I still do that, but that's what is on the data collection sheet is the air conditioner a Rheem? Is it a Lennox? What is it? The warranty company likes to know what it is, because if they have to go out and fix it, first of all, they want to know, was it a pre-existing condition? Was that unit there before they got the warranty in place? Or what, is it brand new? Or did somebody switch it out? Or what happened to it? So they will pay you $100 if you fill out that form or you fill it out online, you do not get $100 for selling a home warranty. That would be illegal. Okay. You're getting paid to do a service. One of the biggest things to remember is I know some agents ask the question, well, why do we have to have a America's Preferred Home Warranty contract, acceptance, or waiver? Why do we have to have our client sign that if in the purchase agreement they say they didn't want a home warranty? Well, the reason is because if you get sued as an agent or we get sued as a brokerage, and oftentimes if you get sued, we're getting sued, you are still responsible for if you're named in a complaint, we have a $5,000 deductible. That is the agent's responsibility to pay. This is your business. We are just assisting you with your business. And so therefore, America's Preferred Home Warranty, as long as we have that acceptance or waiver in place and on file, they will pay 75% of your deductible. So that's huge. You would not have to come up with $5,000. You'd have to come up with, I think it's $1,250. So big difference. And so that is the reason that we require all agents to get that signed by a seller and a buyer. Okay. All right. Consumer guide and buyer agency agreements. So consumer guide, that came into play, I want to say in like 1996. The consumer guide must be signed by your client when you go to show a property or before you show them a property. Sometimes you could show up at the house. We could show up at the house and go over the consumer guide, get the client to sign it. The client could also say, I refuse to sign the consumer guide. And that would be okay. We would note it. We would show them the house and move about our day. Buyer agency came into play in August of 2024, and that is no longer the case. A buyer cannot refuse to sign a buyer agency agreement. They must sign a buyer agency agreement with you, and we have to keep it on file. As part of the buyer agency agreement, because the consumer guide was first, you have to get both of them signed. So there are two documents that you should be getting signed by every buyer before you're showing them a property. One is the consumer guide, and one is the buyer agency agreement. The consumer guide needs signed before you speak to a client about any type of financing, any type of loan that they might get, their finances as far as cash down. You're supposed to get that consumer guide signed first. The buyer agency agreement is something that is specific to working with that buyer for a period of time. The consumer guide is not. The consumer guide is just how we work as real estate agents at Keller Williams. All right, so I've not heard really too much feedback from buyers refusing to sign either document. So you just want to make sure that you get it signed. I think it's a great idea if you're talking to a buyer to get it signed before you get to the house, because that 5 pages is a lot to try and go over at the property. And they might say, well, I'm not going to sign this or whatever. Well, if they're not signing it, you can't show them the property. So you're kind of defeating the purpose of the agreement. If you go show the property, they refuse to sign it, you're breaking the law because they didn't sign it. And 2, you just wasted your time because they're not going to pay you if they buy anything. But then we have to keep those on file for 3 years. So you want to make sure that consumer guide, whether a buyer buys with you or doesn't buy with you, you are required to keep that consumer guide for 3 years. So what I do is, like, this is January of 2026, I'll create a new loop and dot loop and say consumer guides 2026. Then every time I get a consumer guide signed, I upload it in that dot loop file and I save it. Then if a person buys with me, then I pull that over to the new loop of whatever property they're buying. But otherwise, I have it on file for the next 3 years because I showed that person a property. Okay. And the same thing with the buyer agency agreement, we're required to keep those for 3 years. So whether a buyer buys with you or doesn't, you should be uploading those documents and keeping them somewhere in dot loop, or you can keep the paper file either way. If you scan it in a dot loop, you can get rid of your paper file. You can shred that or whatever, because then you have it electronically. But it must be signed before working with a client. Working is defined as showing properties, talking to them about financing, any of that stuff. So I kind of went over that. And it's signed per client. It is not signed per property. Okay. Showing a house, this seems very elementary, but I just want to, I always talk about this and add it in here because there are showing remarks in showing time. And sometimes they say, do not turn off the lights. Sometimes they say, make sure all lights and doors are turned off. Sometimes there might be a note in there that says, be careful, there is a pet in a cage in the basement. Or it might say, do not lock the door between the house and the garage. The seller doesn't have a key for that door, and that's how they access their house. And inevitably, agents will lock that door and lock a seller out of their house. So pay attention to the showing remarks. Should you remove your shoes? Are there cameras in the property? Are there dogs or cats that you need to leave certain doors open so that they can get through? Be on time. If you are not going to be there during the time in which you said you were going to be there, call the listing agent, let them know, give them a heads up. Because if you show up 30 minutes after the time that you were allotted to be there, you're going in the house with unauthorized access. And that is a huge violation at the Division of Real Estate. So you should not just be randomly going into properties without permission. Always make sure you're on time and get the permission. Never leave the lockbox open. So I see agents do this all the time, especially in this market. There's a combination lockbox. I'm the first one to show up. All of a sudden, there are 5 other agents there. I don't know who's an agent, who's not an agent. And I just leave the lockbox code, the front part of the lockbox sitting, let's just say, on the stand inside the living room door. And I don't lock the house when I leave because there's 5 other agents showing it. And I just think, well, one of them will lock it up. Most of the time, there's not a problem with that. But unfortunately, if you're the one that opened the lockbox and you didn't resecure the property because there were overlapping showings and so many agents, unfortunately, one of the 5 of you is going to get in trouble, perhaps if there's any damage to that home and or if somebody breaks in that home or somebody leaves the door unlocked and the seller comes home and finds it. So it's always a good idea to put the lockbox back together and lock the door when you leave. There could be still people inside and they may get angry at you, but you're doing your job to make sure that you secured the property and left the property as secured as it was when you arrived. And then they can leave and lock the door. You can say, I locked the door. Even take a video or a photo or whatever just to cover yourself, because we have had it where there are constant showings all day. The seller gets home and they're angry because now there's mud on the floor or something is missing or somebody left their door unlocked or the lockbox was still on the same code that you can get in with. The agent didn't retumble the lock set, and sellers get very upset. And I would too, because I mean, your home has all your valuable stuff in it, family heirlooms, things like that. So you want to make sure that it is secure. And then leave a card. I always say it's a great way. Leave a card on the counter, on the table, even if the house is vacant. That way, when somebody gets home or somebody shows up, they know that you were there. They know. Because a lot of times you might be saying, well, I'm going to get there between noon and 1 o'clock. And a seller might run home for a minute thinking, oh, I don't know if they've been there or not, but I have to grab something, or I'm going to go home early and see if they were there. Well, if all the lights were left on and you didn't leave a card, they're not going to know whether you were there or not. So leave a card so that somebody knows you were there. Again, I talked about turning on the lights or not turning off the lights. It just depends. Read the broker remarks. Make sure all doors are locked. Pay attention to those remarks. And then the combo lockbox, don't leave the code on the lock when you get it. Because if the lockbox code is 0000 and you leave it on 00, anybody can go up and walk up to that lockbox and open it. Okay. Feedback, I'm hearing different things about this. I always provide feedback, and I am honestly that butthole agent that if you don't leave feedback, I have showing time set up to where it will email you 6 times asking you for feedback. And it randomly does it. I'm sure it has a scheduled of events, but I leave it on 6 until you give me the feedback, because I think it's only disrespectful to go into somebody's home, the client doesn't like it, and that you left no feedback. Now, the reason I say I'm hearing different things about this is because recently there was a lawsuit where an agent filled out the feedback for their buyer saying that the buyer didn't like the property for whatever the reason was. But then the buyer decided, even though they didn't like the property at that moment, they reconsidered it and wanted to make an offer on it. And the seller refused to accept their offer and the terms because they were upset about the feedback they received on their house. And so it harmed the buyer. I've never seen that happen. There's only one case that I'm aware of that's documented for that. And our attorneys are still saying, yes, you can provide feedback. Now, you want to be tactful, but I will tell you that if a house smells like cat urine, I will put in there, I'm sorry, my clients didn't like the house, and there's an overwhelming cat urine smell or odor or whatever. I mean, you want to be tactful with it, but you do want to give feedback, because that feedback, as we have longer market times, it's great for agents to be able to reduce the price or give the seller feedback on why their house isn't selling. So you can give feedback in any number of ways. Supra has a link. Showing Time has a link that'll email you. You can send a text message or you can call the agent, but it's always a good idea to provide feedback. And then working with agents, I think that, this is something that I learned very early in my career. A lot of agents think, oh, well, I just need to win to get the deal. I don't care about the other agent. I care about my client. And part of that is true. The thing is as real estate agents, you need to be courteous to the other agent because this is not a lose-win situation. You're going to work with that agent again. And you might think that you have the upper hand right now and you can be difficult because you're the listing agent. And unfortunately, then when the shoe is on the other foot and you become the buyer's agent and they're the listing agent and you submit an offer, believe it or not, that agent's going to remember that you were difficult to deal with. And if they have multiple offers, they might say to their seller, we've got three offers here. They're all three good offers, but I can tell you working with this particular agent is very difficult. Working with this agent is a breeze. What do you think? And the seller's probably going to say, well, let's work with the agent that's a breeze. So you can really harm your own clients by being rude, disrespectful, or not courteous to the other agent. So again, you will work with that agent again, whether you think you will or you won't. So follow the rules. Also, don't give away client information. There are a lot of agents out there that are very savvy, and when you call them and say, "Hey, I'm going to send over an offer," they'll ask questions that you legally can't answer. Questions like, well, can your buyer go higher? That offer seems a little bit low. Or is your buyer relocating to here? Or is your buyer getting a divorce? Why are they moving? Why are they interested in this house? They'll ask all kinds of questions. And if your seller, or I'm sorry, if your client didn't give you permission to answer those questions, you shouldn't be answering them. So, uh, a lot of times, we write offers that are not so great, and then we give it to our friend at whatever the other company is, go, hey, I know this isn't so great, but go ahead and present it. I'm sure I can get them to come up. You should never say that because you're not working in the best interest of your client. So don't give away information that you shouldn't be giving away. Keep the lines of communication open. I am working with an agent right now. The communication is terrible, absolutely terrible. It takes days for them to get back to me. When they do, I get half the information. It's very difficult to do a transaction that way. So please keep your communication, good communication between you and the other agent. And know when to call versus text. Your clients, this is a huge decision for them to buy a property and to invest in it. And so, therefore, sometimes if you're giving bad news or you're giving any news, you might want to call them so they can hear the inflection in your voice, or you can calm them down if it's bad news. Sending text messages, I have seen more arguments in text messages than I ever have over phone. So you really need to know when to call your client versus texting them. The same thing with the other agent and or lender. Earnest money deposits, we'll talk a little bit about. Cash is never acceptable. We can take a personal check up to $10,000 or a cashier's check. Anything over $10,000 must be wired to the title company. We do not hold earnest money at Keller Williams Legacy Group. You can let that money get held by the title company or the other brokerage. There's no law on who can hold the earnest money, but it's always recommended that a broker or a title company hold that. Who collects the earnest money? Well, if it's the buyer that's paying it, if they go online, they can use the Earnest app on most of the websites and they can pay their deposit that way. If it's a check, you are probably collecting it as the buyer's agent. You don't have to. You could say drop it off at the title company if you wanted to. But you do need to make sure the earnest money gets there as the buyer's agent. So our contract, I think it says 72 hours. You need to make sure that within 72 hours, the buyer has deposited the earnest money. And if they haven't, you need to let the listing agent know that they haven't deposited and the lender, if there's a lender. It is your responsibility to make sure that earnest money gets delivered properly and in a timely fashion. If it doesn't, you have to alert the other agent, and perhaps you might then have a dead deal. So if you get a copy of a check, or if you get a check, send a copy of the listing agent. If they go through the title company, most likely the title company will send you an email telling you that they received the earnest money. And then what happens if a deal falls apart? Well, in the state of Ohio, there are only four ways that earnest money gets distributed. The first way is a successful closing. That's the one we always like. The earnest money from the title company obviously then goes to the seller because it's just a credit for the buyer for whatever the amount is that they pay. The second way would be if we have a fully executed mutual release that says who's getting that money. Is it the buyer or the seller who's getting that money? The third way would be if the buyer and seller refuse to sign a mutual release and the property doesn't close, would be a court order. So if we receive a court order, we have to release it. And the fourth way is if we don't get any one of those three first things to happen, then we have to send the money back to the state of Ohio in the name of the person that deposited to the unclaimed funds. And unfortunately, there's tons of money in the unclaimed funds in the state of Ohio in people's names. But that's what the laws are that are required for the state of Ohio. That's not us making that up. That is what's required. Seller's net sheet. One of the things I always like to recommend is if you don't have the title capture app downloaded either on your phone or if you don't have it saved on your computer, I highly recommend it. You should always be doing a net sheet for your sellers. When you go out and you do a CMA, you should always give them an estimated net sheet that shows what your commission is, what the closing costs are that they're going to have to pay, their property tax proration, so that they can say, "Oh yeah, you're going to list my house at 300,000 and I'm going to net 270. Great. That's what I wanted to see." Now, you may not always have what their payoff is, and their payoff can fluctuate, and that's okay. But as long as you have the estimated title cost, this title capture app will do it all for you. All you do is put in whether the seller has paid the taxes for this year or not, what the tax amount is semi-annually, and what county it's in, and it will automatically populate all the information based on the sale price. All right, that is all I have for you guys. If you don't have any questions, we did that in just about an hour. I'm happy to take questions, whether they are pertaining to what we just went over or not, if you guys have any. I hear nothing. So if there is nothing, I'm going to go ahead and let you guys go. Hopefully you found that useful. Lily, you just unmuted, so I'm going to let you.
I was curious, did you say that the slideshow is in the drive?
No, the slideshow is not in the drive, but I can certainly share it. Are you talking about Gina's drive?
Yes.
Yeah, I can share it with Gina and she can put it in the drive. That's not a problem. It's not in there. The information I was talking about is in dot loop. Uh,
Okay.
and the information, it's really about the brokerage, like our license number, our EIN number, all that stuff.
Okay. All right. Thank you so much.
Yep. Okay. Paulette, you said I share to both, but put presented by Keller Williams Legacy Group. Yep, that's good. Yep, that's fine. Ginger, wait. Okay. Do you need to sign the edit status change form? Oh, good question, Ginger. I love that. Thank you. I do not need to sign the edit status change form on a listing. If you are doing anything as far as withdrawing the listing, I don't need to sign it. If you are changing the price, increasing the price, changing the dates, I don't need to sign any of that. The only time I need to sign an edit status change form is if you're doing a withdrawal with release, because the listings belong to the brokerage, not to the agent. And as the broker, I have the authority to sign and release a listing. And so that's the only time I need to sign it. I know I had an agent, it was very cute, and I didn't say anything. I'll have to go back in my email, but a newer agent sent me an edit status change form because they got the property under contract and they were changing the status change date to under contract, no showings. They sent me an edit status change form to sign. I signed it and then just wrote a note back that said, I don't need to actually sign those. So, but nonetheless, that's the only thing I need to sign when it comes to an edit status change form is a withdrawal with release. And as you brought that up, Ginger, I'm just going to say this again. If you are withdrawing a listing with release in the MLS because your intentions are to relist the property the next day at a lower price, you have to withdraw it with release. If you just withdraw it, that doesn't release that current listing agreement. You will not be able to relist it, and most likely you'll be audited by the MLS. Okay. Anything else?
I have a advertising question.
Yeah.
Okay, so say we've closed and I want to put on social media, hey, I sold Bonnie and Clyde this house.
Mhm.
At that point, do I need to get permission from the listing agent?
No, you do not. As long as you were a party to the closed transaction, you can then say that you sold the property.
Gotcha.
So that is common. Uh, it's a common practice that agents will say, just sold, congratulations to my buyer, or whatever. Now, what you have to be careful of is if you use a photo that you didn't take or your photographer didn't take and you just use the MLS photo, that's a problem because the photos belong to the person that took them or the photographer that gives permission to somebody to use them. But we, as a different brokerage or a different agent, just because I had listing photos taken by Joe Schmo and you sold the property, if you now steal my exterior front photo and say, congratulations, my buyer, they did, I could turn you in and have you remove that photo because it was mine. And I
That
own it.
makes sense.
Yeah. But nope, as long as you're a party to a transaction, boys, I stuttered today. As long as you're a party to a transaction, you can absolutely say that you sold it.
Okay.
Anybody else?
Can you show me how to scan my physical paper, fire and consumer guide?
Yep. Yeah, I'll show you that back there. Yeah. All right, guys. Well, if nothing else, I hope you have a great day. Thanks so much for coming. I hope you all stay warm.